फिर सर बोल रहे थे कंफ्यूज जाता है
मेरे साथ आ रहा है
वो मैंने मेरे
एक मिनट आई थिंक स्टार्ट
Sir, you can start now.
Hello friends, very good afternoon. Today I, Jay Savla, and my esteemed colleague, Ms. Mohana, senior advocate, will be discussing the paper of leading cases. I understand there are 64 judgments in the syllabus and the list is already circulated to all the candidates. Supreme Court was set up in 1950 and we are in 2023, 73 years have passed. But we only have 64 judgments to study. So I hope the syllabus is not very heavy for us. For the purpose of convenience, what we have done is we have categorized the cases so that it is easy to study them. And I'll just share the categories. Yes. So we have divided 64 cases into about 12 or 13 categories. I will, of course, we can't discuss all 64 judgments. The time span is not enough. So I will discuss few judgments and my esteemed colleague will discuss few judgments. So let me just scroll through the categories of the cases which are in our syllabus. So what we have done is the first category is constitutional law, which of course has a maximum number of judgments from our list. So I am just scrolling it down and I will just discuss the education matter and the matters of minority institution. So in this category, we have at least 3 decisions. The famous judgment of TMA Pai Foundation, which was the judgment of 11 judges of Supreme Court. In TMA Pai Foundation, Article 30 of the Constitution was discussed. It held that minority has right to established education institution and government cannot interfere in the autonomy of the institution. It can only put condition on education or matters related to welfare of students and teachers. Following TMA Pai, other important judgment is of Pramati Education and Cultural Trust. The challenge in this judgment, it's a constitution bench judgment of 5 judges. The challenge in this case was to Article 15 subclause 5 and Article 21A of the Constitution. The bench held that Article 15 subclause 5 and Article 21A does not violate the basic structure. It does not violate Article 14, 19(1)(g or Article 21. Right of children to free and compulsory education was thereafter enacted under Article 21A. The validity of the act was upheld by 2 judges, but the matter was referred to 5 judges to examine the validity of Article 15 subclause 5 and Article 21A. The Supreme Court held that the articles are valid. However, it clarified that right to education will not apply to minority institution because minority institutions are protected under Article 30 of the Constitution of India. Then as we run further, there are judgments on reservation of Indira Sawhney and a recent judgment of Jarnail Singh As we all know, the judgment of Indira Sani was of 9-judge bench, where the court said that the reservation should not normally exceed 50%. But we would appreciate that if the follow-up of the judgments are also looked into. For example, on reservation, recently 2 decisions have been passed by the Supreme Court of India. Maratha reservation was struck down by Supreme Court following the principles of Indira Sani, wherein it held that you can't breach 50% category of reservation. However, at the same time, the challenge to 103rd constitutional amendment was examined by 5 judges of Supreme Court in a recent judgment, wherein the category of economical weaker section was introduced and a reservation of 10% was added. The Supreme Court has upheld this provision in a recent judgment. So it is, of course, it would be appreciated that the judgments and their follow-ups are also considered when we give our paper. Then as we go down, I would like to also discuss the judgment of Pradeep Kumar Biswas. This judgment was of 7 judges, Constitution Bench, and the issue was, what is state under Article 12? Let me for a moment read Article 12 so that we can analyze this judgment. Article 12 of the Constitution is a definition clause, and it says, unless the context otherwise requires, the state includes government and Parliament of India and government and legislature of each of the state and all local and other authorities within the territory of India or under the control of Government of India. Now, why definition of state is important? Because a writ petition which is normally filed in High Court under Article 226 is maintainable only if the institution or an organization falls within the definition of state. So therefore, this became a leading judgment. 2 full principles were laid down. First principle was that if financial, functional, and administrative control is with the government, then in that case, it is a significant indication that it is a state. And similarly, if there is a deep and pervasive control over the company or over the organization by the state, then it would be considered as a state for the purpose of Article 12. But I would not like to stop here. As the law is evolving in this subject, the courts are now saying that you can file a writ petition even against a private institution, provided the private institutions are discharging public function. So it's a progressive judicial thinking, and that is what has been upheld by many judgments. Now let us consider next sub-topic, that is curative petition, Article 142, ex debitio justice. Supreme Court, in exercise of Article 142, have laid down the procedure for curative petition and for the purpose of correction of error. Then we have a category of public interest litigation. The important judgment is Vellore Citizen, because this is the judgment which laid down polluter pays principle. Based on this judgment came various judgments on sustainable development, and then a green tribunal was established. as we move further, we will see a judgment on precedential reference under Article 143(1). This is the judgment by name of Special Reference 1 of 2012, where Constitution Bench of 5 judges discussed precedential reference. Now, let me state the point here. As we know, there was a 2G scam and there was a spectrum allocation by the government without inviting any tender or without any bidding process. The spectrum allocation was struck down, set aside by 2-judge bench. Following that order came a reference by President under Article 143(1), namely that in what all cases should we follow the principle of auction or tender. Whenever there are natural resources to be disposed of, is this procedure mandatory or not? So these were examined by the Supreme Court in Special Reference 1 of 2012. Category 2 deals with separation of power and judicial review. My colleague will discuss. Then separate category 3 is judicial legislation. Category 4, we have about 9 to 10 judgments on the criminal law, and through oversight we have forgotten to mention Nirbhaya case. That detail I will forward in this list of criminal cases. Then let us see category 5, that is arbitration. Now we all know, for the purpose of appointment of arbitrator, an application is required to be filed under Section 11 if the parties don't consent for arbitrator before the court. Earlier in Konkan Railways, Supreme Court held that the power exercised by court under Section 11 is administrative power. But within a span of 2 years, 7 judges of Supreme Court in the case of SBP Company versus Patel Engineering reversed the judgment of Konkan Engineering and held that it's a judicial review, judicial exercise of power. Not only that, the 7-judge bench in SBP further held that while examining Section 11, the court can also examine whether there are any live issues or whether the claim is already satisfied. Following this judgment came a subsequent judgment by the name of National Insurance, which was passed in 2008 by a bench headed by Justice Ravindran. In National Insurance, there were 3 categories laid down while deciding Section 11 application. Category 1 were the cases where Supreme Court said no reference required if there is no agreement or if there is no live claim. Category 2, Supreme Court says Section 11 court can decide or arbitrator can also decide. For example, an issue of accord and satisfaction vis-a-vis insurance company, because it was insurance company's case. Court says both can decide, and it is the discretion of the court as to whether court should decide or arbitrator should decide. And third were the cases which only arbitrator will decide, that is the claim of the party. In view of these judgment, namely the scope of Section 11 in exercise of its judicial power, came an amendment in 2015, whereby Section 11(6)(a) was introduced. By virtue of this amendment, it was held that only existence of arbitration agreement is to be seen. What is now existence of arbitration agreement? The Supreme Court in NL Global 3-judge bench and recently 5-judge bench has held that if the claim is expressly barred by law, it requires no evidence, then it is not a valid arbitration agreement. If the agreement is not stamped, then it is inadmissible. It is required to be stamped. You cannot proceed with Section 11 appointment till the agreement is impounded and appropriate stamp duty is paid. So this is the jurisprudence of Section 11, which has evolved. Now let us consider challenge under Section 34 to an award. We know that the challenge under 34 is on a limited ground. There is no reappreciation of evidence permitted. It's not in court of appeal. Neither interpretation of contractual terms can be subject matter of review before Section 34 court. The Supreme Court, in the matter of Associated Builders versus DDA in 2005, discussed the challenge on merits under Section 34 on the ground of award being against public policy. Now, what is public policy was considered by Supreme Court in Associated Builders. Justice Nariman, speaking for the bench, held, following line of judgments from Renu Sagar onwards, that public policy would mean if it is breach of fundamental policy of India, if it is against interest of India, if it is against justice or morality, or if it is patently illegal. So on these 4 counts, the court held that the award can be challenged because this will fall within the category of public policy. Para 31 and 32 are relevant of this judgment of DDA, wherein court also held that if the award is perverse, then it would be a patent illegality and subject matter of challenge before the court. Now, to narrow down the effect of this judgment came an amendment in 2015. By virtue of this amendment, an explanation was added in Section 34, which provided that a review on merits is not permissible when a challenge is made on the ground that the award is against public policy. However, at the same time, Section 2A was added to Section 34, which said that an award can be challenged if it is patently illegal. This 2015 amendment was subject matter of discussion in a later judgment of SsangYong Engineering and Construction, reported in 2019, which is on screen, volume 7, SCR page 522. In SsangYong, again Justice Nariman, speaking for the bench, held that even though the ground under public policy may not be available, but if an award is perverse, it can be challenged on the ground that it is patently illegal. So this are the discussion as far as arbitration is concerned. Then we go further and we will discuss the category 6, which is insolvency and bankruptcy code. We have 2 landmark judgments in the syllabus, Swiss Ribbon and Committee of Creditors, SR Steel. Swiss Ribbon and Committee of Creditors are important because the validity and virus of provisions of IBC were considered. Now, IBC is a new branch of law. The appeals directly lie to Supreme Court. What is the object and purpose of the code? Earlier, we had various statutes there was Sikh Industries Companies Act, Debt Recovery Tribunal, Insolvency Act, Provincial and Presidential Insolvency Act, and Winding Up Provisions of Companies Act. All these provisions did not give desired result, and therefore they were reorganized and they became part of IBC, that is Insolvency and Bankruptcy Code. Now, the purpose of IBC is to maximize the value of the asset of corporate debtor so that a new management can take up the company as a going concern. The purpose is to promote entrepreneur to take over the old management so that the dues of the creditors are paid in timely manner. The purpose of IBC is not mere recovery proceedings, but to ensure that the company is put back on its feet. What was discussed before Swiss Ribbon was the categorization of operational creditor and financial creditor. The challenge was made that there should not be a separate category of operational creditor and financial creditor. As per the scheme of the Act, a committee of creditor is formed of financial creditors. The committee of creditor will decide and will confirm who will be resolution professional, who will run the company in their interregnum, and committee of creditors will confirm the resolution plan. It is the wisdom of committee of creditors which will prevail over any other decision. So a challenge was made that an operational creditor should not be kept out of the committee of creditors as they have also lent an advance loan. But the Supreme Court said that financial creditors are required to be part of COC because normally they are bank and financial institutions who have advanced loan from the very beginning, and the loan is secured by way of some security. SR is also an important judgment on IBC because it discussed the commercial wisdom of committee of creditors. Then we will discuss the category 8. As the time is running short, I will run through fast, of contract, commercial, banking, and competition law. In this, let me just analyze Kailash Nath Associates. This is a landmark judgment because it discussed two aspects. First, can an amount paid by way of an earnest money be forfeited if there is no breach of any party? Supreme Court says no. The company cannot forfeit the amount if there is no breach. And secondly, what are the principles for the purpose of Section 74 of Contract Act, which provide that in case of breach, liquidated damages, that is predetermined damages, would be paid. The Supreme Court said that the amount which is mentioned, if it is in the nature of penalty, it will not be awarded, but reasonable sum would be awarded. The Supreme Court further said that there should be some loss to the company or to the party who is complaining of breach. It further said that even though actual proof is dispensed with, you have to show some proof if it is available with you. Then I will run through other judgments. We have judgments on Competition Commission, tax matters, right to information, then civil jurisprudence and review, appointment of judicial officer, and the last category is intellectual property and consumer protection. Let me just analyze the judgment of Dr. Balram Prasad. This decision is of Supreme Court. The matter traveled from National Consumer Dispute Commission. The issue was, how do you compute compensation? In this case, a patient had come from US and he suffered medical negligence in India. The court held that both hospital as well as the doctor would be responsible for medical negligence of the doctor. More importantly, court held that in computing compensation, we need not follow the multiplier ratio, which is normally applied in motor accident cases. What we need to examine is what are the pecuniary and non-pecuniary damages caused to the patient. What is the compensation that will put back the patient had this operation be successful? So this, according to us, is also one of the landmark judgment placed in our list. With this list, now I would request my colleague to give her views on judgments. And I'll just stop sharing.
Thank you, Jay.
Yeah.
It was very nice and elaborate with a clear understanding of categorization. Dear friends, I can see more than 300 people logged in. It's not like the personal discussion that we used to have for AOR lectures. This time it's virtual. So we are all in our comfortable positions while discussing this. Yeah, I will just see before I go into this categorization, number of cases and other things. I'm going to be very practical in my approach, and I'm going to give you certain tips for writing the examination, what you should concentrate, how you will be able to face it in a better manner and score better without any tension. And also I will discuss very few important cases which you may have to, while reading, how to go about these judgments and prepare for your examination while reading these cases, which I will be referring to. One is I'm very amused to see a lot of our friends are putting on the chat box, please give us some hint about what questions are likely to come, etc., etc. Actually, the whole idea is to prepare you, and you've all been practicing at least minimum 5 years and upwards. So you may, from the categorization and from the discussion that is going to follow, probably you will get an idea as to how to concentrate. Like I know even from 10th standard onwards, we used to group our lessons and then say, this portion is very important, at least one question will come from this area. It is for that purpose. And also when a question is asked, you people are expected to at least know a little bit of the category in which it falls. So it is for that purpose, Mr. Jay had given you categorization. And he has explained a few important judgments from the categories, which are, which you can, where he has thrown more light, so that, you will be in a better position to understand. Now, let me first tell you, in repeatedly when we see the answer sheets, there's some major tip which I want to give you about the exam. See, probably sometimes they give 10, ask you to write 5, assuming that was the last year paper. What are you supposed to do? When we see the examination answer sheets, we find that the first 3 answers are brilliant, very lengthy, very beautiful, covering everything. But as soon as a very bright student, also bright candidate also, when they go to the 4th or the 5th, you know that they have started the answer but unable to finish it on time. So I would advise you, first tip that I will give you is that please divide your time. Please read the question paper clearly and mark which are the 5 questions you are going to answer. This is a 10th standard instruction. Nevertheless, it's not, it's worthy of repeating it again. Read the question, because sometimes a judgment may have more than one ratio. I will explain it to you. Like, for example, we have the privacy judgment of Adar, Puttasamy, and the subsequent Puttasamy. Suppose a question is asked on privacy or on the proportionality. You have to see what is the question. Please don't delve into areas and then waste your time while coming to the subject of the question. So please be pointed sometimes. So therefore, first arrange the number of questions the questions which you are likely to answer. Number two, divide your time into 5, and as soon as keep a watch and then keep cutting the answer within that time given, so that you are devoting equal time to every question. Number two, whenever you think that the answer is going to be lengthy, I'll give you another tip. First, you know the gist of an answer, just put it in one paragraph. Like we do the synopsis, that will also give you an idea how to do a synopsis in an SLP, you're going to be an AOR. So just give the synopsis of what had happened in the case, and this is what the ratio in that case, and this is what it addresses. Give that so that the person who is correcting your answer sheet will know this candidate knows the question and the answer, and she is or he is on the right track. Supposing you are not able to elaborate it in the manner in which you would be liking to do, but because of the time constraint, you are not able to do it, please, at least this synopsis will help you in developing it. Put like a bullet point and then develop it. That's one. Another one is, while correcting, we are all hard pressed and there are so many answer sheets. Please be legible as much as possible, in the sense at least give some space while you are writing, and don't keep writing in a very small letter that we are unable to read it. At least we want to help you, so please help us. So please have some this thing consideration, and when you write, even though it will be very fast, make it at least readable. Length of an answer is immaterial. Please don't think unless I write 10 pages, I'm not getting a mark. No, it depends upon the substance and not the length. Please understand that. That is why I said, please give a gist first and then you elaborate it how much ever possible, depending upon the marks allotted to the question. Then that's what I was saying. The last is that read the question carefully. Now, there are certain important judgments which I will advise you as to how to go about it. I'll take only 4-5 of them. And Balram Prasad, of course, my friend, stopped with that. And maybe I can give you an idea about Balram Prasad is that, like my friend said, Malay Kumar Ganguly is the lead judgment in which Balram Prasad case actually emanated. In that judgment, what had happened, one lady of 35 years had come to India. She had some skin problem. She went to several doctors and her problem was not cured. Ultimately, she died due to the treatment which was wrongly given by the wrong treatment given by the doctors. She had come up to the Supreme Court. The liability was fixed. However, the compensation had not been fixed. So they went back to the National Commission for Quantum. Initially, the claim was 77 crores, which was subsequently amended to that of 97, which was also challenged. Commission had given 1.5 crores as a joint and several liability by the hospital as well as the doctors. However, the claimant as well as the hospital came to the Supreme Court, which is this reported judgment of 2014, 1 SEC 384, which will be in your list of cases. Balram, in your list of cases will be item 30. So in this, in fact, this court had taken, one is, like my friend said, what is the method adopted? She was 35, 36, and expectancy was fixed at 70. And therefore, the court said, at least I will take the multiplier method, which is in the Motor Vehicles Act, and took 30 as a multiplier, and then calculated it and awarded about 6 crores with 6% interest. What is interesting is that they have given what are the headings under which compensation can be given. It's very beautifully explained in paragraph numbers. You can say, I'll give you the paras which you will have to see. 132, that's about joint and several liability. 133, 144. And it said, finally, they've given certain directions. as to how it is to be done. Just this page of this judgment. 1 second. 384, right? Yeah, I'll just give you. You may have to see this angle. If a question comes about what are the essentials of fixing of a compensation, what is a guideline that the Supreme Court has laid down in while fixing compensation in medical negligence matters. These paragraphs which give out the manner in which the compensation is given is at para 74. Please concentrate. What do you mean by just compensation? So the court said in this case, National Commission has completely failed to award just compensation. So a question comes, what's a just compensation? How do you fix a just compensation? So this will be the manner in which it is given. There is a status and qualification of the victim and the husband, income and standard of living in USA because she was living in USA, economic expert from the USA, so they have given evidence, scientific calculation of loss of income and loss of income of the claimant as such, and reducing the personal expenditure, they have arrived at a figure. So it's not about the figure, it's about the base facts. Whenever a question like this is asked, you give at least 4 lines of base facts and how this question has come to the Supreme Court and then give this answer. At least give some details about what is being fixed. That's about Balram Prasad. 74 is the guideline and 94 are the issues about what were decided in that case. Now, let me also give you an example on this other angle of, suppose if there are other categories that my friend was going into. I will take only a few cases from categories because of the time constraint. The suppose I was reading about this case of State of West Bengal and Committee for Protection of Democratic Rights, which is reported in 2010, 3 SCC 571, which is at item number 25 of your list, in the list of cases given to you for preparation. This is a bench of 5 judges who decided this. Very interestingly, what had happened was certain people were attacked and an FIR was lodged in the West Bengal state. And since the progress of the investigation was not on the expected lines, a writ petition was filed by the Committee for Protection of Democratic Rights in the High Court, saying that this should be transferred to the CBI. Now, this was actually allowed by the High Court and the investigation was transferred to the CBI, which was challenged by special leave petition in the Supreme Court by the state of West Bengal. See, how does it come in this angle of, you say, judicial review or anything? Is that the point which is decided in this case, what is very important is that the question of separation of powers, federalism, because if a CBI is a centralized agency, if a state which is doing the investigation regarding commission of an offense inside the 4 corners of a state is doing that, if a CBI has to come in, there should be consent. CBI has been constituted under the Delhi Special Police Establishment Act. If the CBI will have to investigate of an offense, it will have to have the consent of the state, was the argument. The argument was, now it violates entry 80 of list 1 of the 7th schedule. And the arguments of this state said entry 2, list 2 of the 7th schedule is violated. So therefore, we had exclusive jurisdiction. The violation of entry 2 of list 2 has to be taken. Federalism is affected and there is a violation of the division of powers. But the Supreme Court said, when there is a violation of fundamental rights and when it is a case when CBI, of course, being an outsider, it is normally consent is required. But in a case where it is required, the High Court need not take the consent of the CBI for passing such an order of directing CBI investigation in extraordinary circumstances. So this is what the union government contended, that this cannot, they cannot be stopped from going and doing certain investigations in particular states. So the court says, though undoubtedly the constitution exhibits supremacy of the parliament over the state legislatures, yet principle of federal supremacy laid down in Article 246 cannot be resorted to unless there is an irreconcilable direct conflict between the entries in the union and state list. So therefore, there is no quarrel with the broad proposition under the constitution. There is a clear demarcation of legislative powers between union and states. And finally, it is held that Article 21 protects the persons of their lives and personal liberties and according to the procedure established by law, the said article as a broad, application, and therefore it has to be upheld. In that light, in the federal structure also, even assuming there is a distribution of power also, if it is, the answer finally given for this reference by the Supreme Court is that in exercise of powers under 226, the High Court can refer this investigation to CBI in a cognizable offense alleged to have been committed within the territory without the consent of that state. It will neither impinge upon the federal structure nor it violates the doctrine of separation of powers. So this is a very important and a landmark judgment on this issue. Even when you are talking about separation of powers in an indirect manner as asked also, this is one of the very landmark on questions, case law. When we are going into the criminal law angle, there are two important cases. I think I would like to touch upon both of them. According to me, both are important because both work on different areas. One is Sushila Agarwal. As you all know, this is a 5 judges bench judgment. Both Justice M.R. Shah and Justice Ravindra Bhatt have given this. I'm sure all of you have read this judgment. This is about grant of anticipatory bail. How long does it continue? What is the effect of that? Whether any conditions can be imposed? What sort of conditions? And how long does it operate? Here, in fact, there were one line of judgments by the Supreme Court itself, which said, while granting anticipatory bail, no conditions can be imposed. But one more line was that it has to be time limited and also that certain conditions can be imposed. So therefore, this 3 judges bench and the 2 judges bench were referred to the 5 judges. And the court, after considering elaborately, there were 2 judgments, of course, concurring. M.R. Shah gave the lead judgment in which the paragraphs which I will say, they say the Gurbakh Singh Sibia, which was already there, it is also by a constitutional bench, 1980 to SCC 565. So you will have to refer to this when you are writing this. In the sense, when you are referring to this case, you will have to understand the Sibia's case also. It had taken a balanced view about imposing conditions. It can't be in a straitjacket formula, whether it should be completely imposed or completely free. That is left to facts of each case. And therefore, they said Gurbakh Singh Sibia lays down the correct law. So we will only reaffirm what is said in Gurbakh Singh Sibia. Also, it overruled certain judgments which said no conditions can be imposed at all. Siddharam Santalinkappa Maitre, which is reported in 2011 1 SSC, which is considered in this judgment itself. They said it's not correct law to the extent it takes the view that the life of the order cannot be curtailed. It said extreme view was that you grant an anticipatory bail, you can never curtail the timing of the anticipatory bail. That was an extreme view the court thought. It said, no, don't take that. That's incorrect as far as the timing goes. Whereas in this, Gurbakh is a balanced view. And also there is one more judgment which said it has to be necessarily limited. That is Salaluddin Abdul Samad Sheikh, which is reported in 96-1. That order of anticipatory bail has to be necessarily limited in time frame. That is also not a good law. Both took 2 extreme views. So therefore, the court said, Justice Ravindra Bhatt also made a separate concurring judgment. So the very interesting judgment, and it is always necessary for any AOR. I would think that, every AOR at least some point in their beginning of career as an AOR itself, they'll get some anticipatory bail or the other, because we all end up here. Nowadays, the anticipatory bail, sometimes we have to get it only from the Supreme Court. So I think all of us need to know, at least for our academic knowledge, if not for the exam, but I would think this is a very important question that will come, that, that will be raised time and again, that question of anticipatory bail, whether it can be limited for a particular period, and what is the correct law laid down in the recent judgment, that is Sushila Agarwal, which will be probably in your list. It could be, 1 second, Sushila Agarwal was what? Item 60. Then the next criminal law issue is that since I'm on the criminal law angle, I wanted to see this one more case. All of us may think Nirbhaya is a case on facts. Nirbhaya is one of the landmark. The incident as such has shaken the country, and thereafter it went on for some time. And in a 3 judges bench, what is laid down after a very long time, a death sentence has been confirmed. after understanding what are the aggravating or the mitigating factors while imposing death sentence. Because we see nowadays there is a trend that the courts are in fact slowly trying to see, or even there is a public opinion about grant of death sentence. So therefore, for two angles at least, Nirbhaya has lot of criminal law angle to that. Lot of criminal law evidence, CRPC is discussed, Evidence Act discussed. Several aspects are discussed in Nirbhaya judgment, which is 2017 6 SCC 1, which is Mukesh versus NCT Delhi. It's 39 in your list. Three judges, one is Justice Deepak Mishra, one judgment by Justice Bhanumati. There are two judgments. See, in fact, the very crucial aspect in this, apart from other evidence, was a dying declaration, not three. So the question came very interesting. Whether dying declaration, when there were three in number, how to believe it, whether they can be believed, dying declaration by the victim injured can be believed for convicting. However, there were separate, independent corroboration for this dying declaration. There's no doubt about it. But the court dealt with all the three dying declarations, which were given in certain, there was some time limit, gap, 16/12/2012 before the doctor, 21/12/2012 before the second one was before the SDM, third was on 25th December 2012 before the Metropolitan Magistrate. Two of them were only signs, couldn't speak after surgery, but there were certain writings. So court taking into, and there's a beautiful analysis of how to appreciate these dying declarations, whether they can form the basis of conviction is discussed. That's very important angle in that judgment. The second, as I said in the beginning of this judgment, is that about the death sentence, whether in what circumstances it can be imposed, the factors which are aggravating, which outweigh the mitigating circumstances. So that is discussed in several paragraphs beginning from 312 onwards, probably around 340 or so. The discussion will be there up to 366. You will have to at least give some idea about this case, about how it emanated, what were the bullet points of considerations, and how the court came into the finding. See, I feel that what we are studying is not merely for the examination. See, I can tell you, as for preparation of my AOR examination in 1996, I had studied about 40-45 cases. But since we
Not properly, ma'am. Ma'am, the space bar on your keyboard is pressed, ma'am. Please check the space bar on the keyboard. Yes.
So sorry. I think keyboard has that the board which I'm holding has pressed the keyboard. I'm so sorry. Sorry. Did you hear up to this paragraph number in Mukesh? Did you hear this? Okay. So what I was trying to say is that when we prepared for the AOR examination, it is not merely for the exam purpose itself. It helps us to a great extent while doing practice also, because these cases don't rest for a single case purpose. These issues keep coming again and again when you are drafting an SLP or advising a client or arguing before a court, and suddenly the court comes up with a question. You, with your memory or having studied for this examination, you will be able to answer on your feet. So I believe that whatever you are studying, don't think you are studying for an examination. That's an in-between tip I wanted to give. Then two more cases I'll try to talk to you about, and then we'll finish it. I do not know when the link will be cut. I can announce one thing. Our office has made about 7 to 8 judgments notes, and how to study these judgments in a very beautiful manner. My colleagues have helped. Bhavya, Sneha, and my intern, Shweta. They have also helped me in preparing this note for this lecture. So I will ask one of them to share these notes to one of them, take the email address, and please kindly share it with everybody else also, because these are actually an analysis of all these judgments. How much we have prepared. In some of them include what Jay Sabla had also lectured. So those will also be there. So we can share them. Now
We
there are
can give it to, sorry, we can give it to the examination branch and they can circulate it, I think.
That's wonderful. So I can, yeah, just two more judgments I will touch upon, because we do not know whether our link will be cut at the right time, or I am not aware of the procedure. Now, the one more thing on this is Shanti conductors is a case which I thought was very important on two issues. One is it decided on a two interesting point of limitation in a case where interest on delayed payments to small scale and ancillary industrial undertaking act is involved, whether the act alone concerns the period of limitation which got revived due to this enactment, or section 19 of the limitation act can be applied along with this. See, the point here is Shanti conductors had supplied certain materials to Assam State Electricity Board, and the payments were made in principle, but the interest was not paid. One round of litigation got over by the association as well as Shanti conductors separately about the liability. What happened was it was held to be barred by limitation under this enactment also. So therefore it came up to Supreme Court and it got reported in 2019. Please note down 2019 19 SEC 529. The issue got settled and it said Shanti conductors suit for recovery of the interest is not, maintainable due to bar on limitation. What happened? They filed a review. So this is two angles which the Supreme Court decides in this judgment is one, limitation angle, when it is applicable, when it can be revived. Number two is on the question of review. When is a review maintainable? What are the four corners of a review? In fact, when you are talking about review, you can also read for a curative. If you want to ask, you can ask about curative. When question is asked, you can Rupa, Ashok, Pura, and then you read the Shanti conductors. But if only review is there, definitely Shanti conductors. According to me, this is very important on the issue with that. When this case came here, there were two arguments raised. The review was filed, they argued, because section 19 of the Limitation Act was not considered. What does Limitation Act 19 say? 19 says whenever there is a new payment or an acknowledgement of liability is 18. But 19 of the Act says whenever there is a payment effected, and then you have to revive the claim 3 years from the last date of payment, which is, I'm not reading the section as such, I'm putting it to you in a manner in which you will be able to understand. You can read it later. So section 19 argument, they raised it in Supreme Court and said, actually the benefit they claimed was, the argument was in the first round, there is this act which is called as Interest on Delayed Payments to Small Scale and Ancillary Industrial Undertaking Act 93. The initial argument was, interest having not been paid under this act and it has been revived, my payment of interest has not been given within the as per the enactment, so it is due. Limitation is not applicable is what the argument was. That has been rejected up to Supreme Court. But in the review, what they argued, I have to apply section 19. Supreme Court did not consider section 19 because the payment had been made up to a particular date. Suit had been filed within 3 years from that date. So limitation will get revived is the argument. What the Supreme Court said, two things. One, either you say limitation is applicable or not applicable. Having said that this limitation angle is not applicable to you, you can't now come and say section 19 is applicable to you because your limitation gets revived from the last date of payment. So on that score, section 19 cannot be applied is one. Number two, as far as pleadings go, section 19 has to be pleaded specifically. For that, our friends will have to read Order 7, Rule 6 CPC, which the Supreme Court says CPC and CRPC, we don't remember many a times. We leave it in college and come to the Supreme Court. It's only 136 that we are thinking about. So you will have to see this judgment and see Order 7, Rule 6, which says anything about limitation or extension or exemption will have to be pleaded specifically. So therefore, since you have not pleaded it in your plaint And now you are agitating as a new ground in your review, section 19 angle without a pleading. A review itself is not maintainable. So in this judgment, if you go through, you will find in paragraphs 14 onwards, how is limitation angle dealt with and how this pleading has to be decided in para 22, 23, and earlier cases are dealt with under order 47. What is a review? What are the four corners of a review when you come to the Supreme Court on an error apparent on the face of the record? So will have to be dealt with only under order 47. So this review is not maintainable. On that score, I thought Shanti Conductors is a simple case, but a good case on limitation as well as on this angle of review. Now, finally, Navtej Singh Jogar is one of the very, very relevant issues today because, as we all know, that is, now we have witnessed the 5 judges hearing the declaration for the gay-sex couple to get married. Angle is going on today. The judgment has been reserved last week, so that this aspect of declaring section 377, as unconstitutional, which is violative of article 19 1A and 21, is a very, very important judgment which deals with the contentions of how a homosexuality and sexual orientations are neither an illness or a disease. It's just some people are given that kind of, they are also not a lesser human being. These kind of arguments are dealt with and contentions. And the judgment is a very beautiful judgment given by, there are about all the judges, all the 5 have written a judgment. Chief Justice Misra, sorry, there are 1, 2, 3, 4 judgments. One is Chief Justice Deepak Mishra wrote for himself and Justice Kanvilkar, Justice Rohinton Nariman, Justice D.Y. Chandrachud, Chief Justice, then Justice Indu Malhotra. They've all given the key points discussed in this judgment are right to equality and non-discrimination, freedom of expression, right to life and personal liberty, the order of nature. Nature, what is constitutional morality, whether we have to abide by constitutional morality or the society's morals, Yogya Karta principles. So these are very beautifully explained, and I would request you all to read this judgment so that this is going to be useful for you even in the coming days, because there will be a follow-up of this also, which will be pronounced in the recent times. The last but not the least is Puttasamy. The Puttasamy has 2 judgments. I didn't give you the last 2 of the item numbers of your list, but you can choose, you will Navtej and all, you will be able to see item 47. Puttasamy will be 48 and 43. 2 of them are Puttasamy. So in this Puttasamy also, first judgment is about whether privacy will come under Article 21. Yes, it will come under Article 21 is the lead judgment. But subsequently, when the Aadhaar Act was enacted, UIDAI authority was brought in. That was challenged. Several provisions were challenged on several angles. Justice Sikri wrote for Chief Justice Deepak Mishra and Justice Kanvilkar. That was a majority judgment in which they said Aadhaar Act is valid and it does not affect the right to dignity and the 2 facets of dignity, that is individual dignity and the community approach to the dignity. And specific provisions of the enactment were struck down. That is in para 513 that has been struck down. There is a discussion about what are the provisions which are struck down, and the findings you can see from paras 351 to 368 about the validity. And Justice Chandrachud gave a dissenting opinion saying that the act is unconstitutional. And the one angle which was discussed in this is about what is privacy angle is the first judgment. The second one describes what is proportionality. Whether there are 3 tests in this judgment, what is important is that the 3 tests which were given for checking of the enactment, testing the validity, is the 3-fold test which you will find in para 975 also, is the legality, which postulates the existence of the law, the need defined in terms of the legitimate state aim. Thirdly, the proportionality, meaning which ensures a rational nexus between the object sought to be achieved and the means adopted for getting the legislation in place. So these are the tests. While the majority opinion thinks it passes all the tests, the minority thinks it does not pass the test. So therefore, there may be a very important question regarding Aadhaar or the Puttasamy or something is In my understanding, this is one of the very, very important. I'm not, I can't vouch for whether it will come or not, but I can tell you, in my view, this is one of the very, very important judgments, both the Puttasamy judgments. Please go through them. Some paragraph numbers, I can tell you, even Justice Bhushan had also given some his opinion separately. Justice Bhushan had given a concurring opinion, but he had been a little more conservative as far as the enactment is concerned. He had in fact said, in fact, certain provisions which were held by the majority as valid also, he said it could not be some provision. I mean, they are valid, he said. So it can't be treated as a money bill is what Justice D.Y. Chandrachud said, whereas the majority says it can be. So please go through this. And certain directions have been given in that judgment as to where it can be applied, where the Aadhaar cannot be made mandatory. That is also given in this majority judgment as to where it cannot be used. That you can find in para numbers 378. And Aadhaar and PAN linking is valid, and whether it satisfies the test, please understand that paragraph 486, 503 and 512. Kindly see those paragraphs that are, and kindly see how to read a finding in a judgment and ratio decidendi. So you will be able to give an answer to the questions. Therefore, I would request all of you to please read the questions twice before answering them. And I hope we were able to give you some inputs about this examination, because this is quite a lengthy list and we can't cover, like Mr. Jay Savla told you in the beginning. But whatever we felt were important have been discussed here.
Yes.
At least I have only concentrated on those important angles. I can also probably, I can give you some idea about, you know, these among the categorization, you can actually look into these things, what we said. And IBC, of course, my friend has explained that Swiss Ribbons and the Committee of Creditors, and of course, Sanyong and SBP. SBP, of course, has undergone major change, but nevertheless, I think it's a base judgment which you can. Pramati, of course, says except minority, the right to children education. These are angles which have not been, you know, recently also tested. So in my view, you may concentrate on these and what we discussed today while you are preparing. Definitely, you must understand whatever you are studying. It's not only for the examination, please remember. And best wishes to all of you.
Thank you. It was a wonderful, insightful discussion, Mona Madam.
If you have any questions, if we have time, I can really.
I just wanted to say two things. Firstly, the style of paper. It would be 20 marks question, 5 to be attended out of 10. That is what we have suggested. Of course, it is for the examiner committee ultimately. So if it is 20 mark question, it may have sub questions, but total marks would be 20 per question. And second thing I would like to state is that when we go to court, we always cite the latest judgment. The principles are laid down in earlier judgment. For example, if you go to section 34 petition, Sanyong may be one judgment, but we will cite recent judgment of Delhi Metro Express, etc. So I would appreciate that if any follow-up is mentioned in your answer, that would be of great help. So we both wish best wishes for your upcoming exam, and we will share the list, and the note will be shared by Mona's office. So we will give it to the examiner committee, and I'm sure they'll share it to the students.
We have actually prepared only for 10-12 cases. We will give it to the registry or somewhere. We'll just try and share it. Only thing is, if there is anything, if you want to ask, please ask. And like Mr. Jay said, if you can show some development of the law till the latest ones, it will show only that you have understood the case properly. That's all. But don't think that only then you will get the 20 marks on that. It will be better. It will show your growth only, and it will tell the examiner that you have actually prepared and followed up, and you have understood the question well. That's all. So,
thank you.
Yeah. Anybody wants to ask anything? But they are all muted, is it? But there is a question here in the chat box.
Yes, you'll have to answer the chat box. I suggest we have answered most of them.
Be grateful if the registry, yeah, there it will be provided.
Right.
Yeah, length of an answer, there is no ideal length. Somebody has asked. Kindly see that, as I told you, divide your time and put an answer, how much ever possible from the answer, please put it. If you think you cannot do it, at least put it in a gist and finish it.
There is a question about structure of paper. which we have explained that it would be 20 marks and it would be from different categories. So you have to study all the categories, the relevant judgments, and there would be option given also.
Somebody has asked, is it mandatory to write facts and issue of the case? It will be, the question itself will be coming from out of the issues only. So you will have to say this issue arose in the fact situation in 5 lines or 4 lines, you can do that. This is the fact situation. At least you should know from where the cases are arisen. You can't simply read. Anyway, you would have read the facts and then only come to the, the findings.
There would be no objective questions. Basic structure we could not discuss because of less time. But Keshav Nanda Bharti is the lead judgment on basic structure.
Somebody is asking why Aadhaar law is not struck down. The reasoning is given because it satisfies all the tests laid down for test of a legislation, which is what I told you. There are 3 tests. As per the majority opinion, it satisfies all the tests. Therefore, it was not struck down. Minority struck it down.
Ma'am, you need to answer this. They are asking, do we have to write majority as well as dissenting view?
Depending upon the questions. But you can always put in 2 lines if there is no specific question about majority or minority. While writing the answer, you can put the majority. Depending upon the question may be only touching upon the majority view. Why was it struck down or why was it not struck down may be the question. While it's not even asked, then you can write as a note that while in the minority it was given like this majority contained 4 judges or something like that. You can give some inputs. Or if the question specifically is asking you minority view also, then only you have to give. Otherwise, it's all right. Out of 10, you may be able to answer 5. Ask to answer 5.
We have said 10 questions. Let us see what ultimately committee has to say. But out of 10, any 5 can be attended.
Yes, you can give your own views about every judgment.
Yes.
That will show that you have analyzed the judgment well. So this is not a court argument. This is a testing, how you have understood the judgment. You can give, if you have any critical views about the judgment, you can always give your opinion. No problem at all.
Ma'am, there is a direct question. Which judgment would come in exam?
Beautiful.
Would you like to answer that? I think if you have attended the lecture and if you have studied well, you all should get full marks.
Somebody
Okay.
100 on 100, how to get it?
Okay, thank you very much. I think we had a very interactive session and thank you all for joining and all the best.
Thank you.
Thank you.
Thank you very much.
Thank you, office. Thank you very much.
Thank you. Thank you. Thank you, Mr. Jai Savla. Thank you, sir.
Thank you, madam. Thank you, sir. Thank you very much.
Thank you.
नहीं रिसीव तो करेगा जानते हैं